Can you imagine, Jamaica, how many people this woman has prosecuted with a tamper jury? And all she's saying to you, nothing wrong with it. And basically, that's she's telling you, you know. She basically saying she's going to retrial. She adamant she's going to retrial, you know. So there was a press release that was handed out today by the attorneys representing Vybz Kartel and the co-accused. So I'm going to read it now. The defense team for the recently cleared Sean Campbell, Adidja Palmer, Andre St. John, and Kyra Jones take note of the public reports and comments after the United Kingdom Privy Council decision on the matter. We note the very public attempts to amend the Jury Act to affect the rights of accused persons through a jury trial. Because this man, only way we get up and here say them are go amend the Jury Act. All of a sudden, the Jury Act going amend with high priorities. We remind the public that the United Kingdom Privy Council noted that the board notes that there was no evidence to connect any of the defendants with the activities of Jury X. We hope that this will not. We hope, here it is. We hope that this will be a sufficient answer for the charges and the counter charges and the corruption in the jury system and the unfounded attacks upon the integrity of the accused and the defense counsel at trial and appeal concerning the activities of Jury X. We note that any attempt to associate our clients with alleged offers made by Jury X is bound to act adversely against them in the minds of potential jurors should the matter be retried. We ask that the relevant state organs be mindful of this in public utterances and actions. We also note the media reports indicating the DPP's published view that a misinformation campaign is aimed at intimidating her office after the cartel ruling. We are unaware of such a campaign and are not a part of it. None of us, the defense counsel in a matter, intend to bring the office of the DPT. We intend to, in this matter, intend to bring the office of the DPP into disrepute or to rile up any wayward soul to take any inaction against the crown or public servant. As ministers of justice, we are only focused on, hear this now, on a just outcome in the matter. I won't ask all persons to desist from any PR campaign in this matter. So, who Paula Llewellyn has said has spread misinformation? Lord Jesus. We look forward to arguing the Privy Council referral of this case to the Court of Appeal. We would never dream of taking any actions outlined by the learned DPP. After almost 13 years of the accused men being in custody, we genuinely believe that this is a fair outcome and their discharge without a retrial. The DPP's action in this matter, as a matter of public record, there were no influenced by her personal view of what the justice of the law of the case required. The board in paragraph 47 of its decision noted that the prosecution had approved of the course which the judge followed. It further stated that the course followed by the judge was a material irregularity in the course of the trial, giving rise to the miscarriage of justice. Any comments we have made in the past simply underlines the importance of the DPP or her office learning the lessons of this teachable moment. We suspect that our views of this outcome of the retrial issue differ significantly from that of the DPP or the sectors of the public. We expect the Crown to prosecute, while we will try to provide our client a fair and strong response. We will focus on preparing our submissions for the Court of Appeal and acting as reasonable legal professionals. We do not expect any actor, defense, Crown, or state to be attacked, maligned, ridiculed for doing its job in this matter. There's something so fine, Jamaica, you have to say with me. I need back my glasses. We will not make or answer any substantiated emotional attacks or counter attacks on this matter. Emotive responses will not assist the court or the administration of justice in ensuring our just outcome or advancing our client's best interest or case. We know that our DPP will always take the action she deems fit in this case. We urge all actors, public and private, to allow the Court of Appeal to properly be sized on this matter and refrain from seeking to try the matter in the public space. We will not advance the best interest of justice or the best interest of justice of any of the relevant parties in this matter. You hear that? So that was a press release. Is my attorney there? Is Jamaica's favorite attorney there? Yes.
Did someone say my name? Did someone say my name?
Wow, your color's bright tonight.
You know, you gotta make green. You have to wear green if you want to make them scream. Yeah. Anyway, what's up? Good night. How you doing?
I'm good. Learned attorney.
Yes.
This morning I was appalled when I heard the pronouncements from the Director of Public Prosecution. The Director of Public Prosecution basically has admitted that time and time again the jury has been tampered with and she has proceeded with such. I can't sit and come to the reality that a lot of innocent people, a lot of people could be put away and they're innocent, and this is the situation where a jury is tampered with. And the Director of Public Prosecution's office has decided to proceed with it. What's your take on that?
Well, here's the thing. The press release speaks for itself. The defense certainly stands united in taking the position that, listen, we're not trying any case in the media. There's no need for clarifications after the fact, because if one, this is why context matters. If one looks at the judgment of the Privy Council, everything that you need to know and everything is in the judgment in relation to the facts that are before the court, or before that was before the court and what the Privy Council pronounced on. The next thing I will say is, in an adversarial system that we have, the criminal justice system is an adversarial system. What people must understand is that the defense, as creatures at the defense bar, is there to defend, albeit being an officer of the court. They find themselves defending. Similarly, the prosecution, they too, as creatures at the bar, are going to prosecute. It is in their nature to prosecute. What is clear in terms of the ethics, the ethical implications, is that defense win cases, prosecutions do justice. So where emotions are concerned, one can strip the reality of the emotions and think we must not be blindsided or distracted that what has happened is a monumental decision that has implications for the common man. Take out who these popular defendants are. That's how I'm going to refer to them as, and know that your brother, your sister, your father, somebody who is not of means, is expected to be cloaked in the presumption of innocence, is supposed to have what is known as fair trial. So when somebody says that the Constitution says has been, is being, and is likely to breach the constitutional rights, we must give effect to the Constitution and understand that when Justice Sykes speaks about the importance of the Constitution in needs and the way forward in how we interpret the Constitution, no one should be allowed to breach constitutional rights and treat it as if it is not a breach. This is generally. So to have the public put on their critical thinking mind.
Yes.
What is it that we must accept as a people? Is that if we want better, if we hope to one day get to Singapore, there are just certain things we are not supposed to allow to happen. No, we are guided as attorneys by the canons, the ethical canons. And it is important to note that those canons, one refers to Canon G for defense attorneys in terms of how they're to conduct themselves as officers of the court. And likewise, one refers to Canon H when it comes to attorneys on the prosecutor side and how their ethical implications and how they're to conduct themselves. What is clear though is the discourse is unfair to the gentlemen. Because the jury pool, we expect, one of the things where the Magna Carta says is you're to be tried by a jury of your peers. Codified in the Constitution of Jamaica is that you have a fair trial within reasonable time by your peers. An impartial jury, a fair and impartial jury. That's the hallmark of a fair trial. One cannot get that when we have these public discourses and have the village lawyers start to make implications against against the and influence the village judges before they get into the court. It has to stop, because this is something where if the Constitution has any effect, and I can tell you there's only one done in this country, and it's the Constitution. So whether you're on the green side, on the orange side, or you're on the justice side, or you have big job, or you're homeless, the Constitution is the done of all dones. And if you're not acting in accordance with the Constitution, you are a degenerate. You cannot do that, and we must never allow anybody, whoever they are, to breach the rights of the citizen. This is generally. But similarly, no, just let me make this one point. Similarly, one cannot allow the platforms, you included, we must not use our platforms to paint narratives, mislead the public, misguide the public, for instance, even by inference. So an article was published in the paper, and there's a conversation about jury tampering. Well, I'm going to make clear to you that a reading of the Privy Council judgment, one of the key reasons why the conviction was quashed is because not one iota of evidence was presented anywhere that the men, all four of them, had anything to do with jury tampering. And if one goes back to my presentation before the Apex Court at the Privy Council, in my advocacy and plea to have that conviction quashed, I made it clear we must never attempt to speculate, because if the public thinks that it is the defendants who are responsible for tampering with the jury, it can equally be put at the feet of the prosecution. And I am saying the basis of the press release is to say we are not to do that. We have to respect the justice process. We have the judicial process. And this went through an appeal that took 14 years to get there, 13 years to get there, close to 13 years to have the matter concluded. The Constitution speaks about delay, and we have all these things to be ventilated. Can the public just step back a bit and allow the justice system to work? It works. I've been saying this all the time. So you can do what you want at first instance.
So you're asking your call and the call from the attorneys representing the men whose convictions have been
is
for us to lay back for a while and let natural justice take its course.
I'm gonna do more than that, and then you can throw big stone at me. Do
what
not,
you want us to
just listen. Do not disrespect the office of the DPP.
But
no, just hear me out. Just hear me out. If you're on the defense side, don't be disrespectful. Don't be rude. Don't put out defamatory accusations that you cannot prove. Just simply do not do that. The facts speak for themselves. The judgment speaks. Listen out, the judgment speaks for itself. So if at any time you are disgusted, it is what the judgment says. Nobody have to add flair and nobody have to put context or angles or anything to it to have anybody say anything. I'm just asking for the purpose of what is happening. Nobody don't need to disrespect anybody, certainly on behalf of my clients and myself. We don't need no advocates to get into what is called the trenches. The defense deal with law. Let those who dig trenches and gamble and do whatever they have to do, let them do it. But we are not.
So you're asking for the personal attacks on the DPP to stop?
To stop and make it clear that not one person on the defense side has made any attack. And we must put things in context. That
because the DPP is saying that there is a campaign of misrepresentation.
Well,
and you're saying that it's not the defense.
I'm going to tell you something. It's only one misrepresentation ever win 8 Grammys. And it's the misrepresentation and miseducation of Lauryn Hill. And that was a good album. But anybody, if you want to fact check, look at the Privy Council's ruling. And if at any time somebody don't understand, I am prepared to sit for 10 hours and read from the top of the judgment to the end of the judgment so that people understand that context matters. I am very happy to say that when this trial took place, I was not a member of the bar. So I was not at the court of first instance. And so
my apologies, repeat that. Repeat that.
I was not a member of the bar and I was not a part of the trial. But what I can say is when I went to the University of the West Indies and I was taught about constitutional rights and the importance of the charter, I've been on this platform and I spoke before as to how young the charter is and how
12 years old.
Yes?
12 years old.
Yes. As old as this trial, and say that the constitutional rights is for all. So I don't care if you dislike Mr. Palmer or any of the other men that are a part of this case. What you need to know is that when the Privy Council made its decision, it made its decision because the effect of the breach of the fair trial rights and the integrity of the justice system, the judicial, the jury system, the Magna Carta, the importance of that would have affected England so much so that a man it cannot be said that a man is only free when he breathes the air in England. And so if the guilty man, the purpose of it is so a fair trial is that when you are adjudicated guilty, is that you do it. We don't deal with feelings. So all people who like to talk about feelings and who from mama want ball and who want do this and pretend like say people are upstanding. We must appreciate that it is the system that we are protecting. And when the apex court has even said, we sympathize with the judge. We sympathize and we make it clear that if there are problems with the law, it is upon the parliament to fix it. But what is clear that there is case law that's guided, and the case law says a man cannot benefit from tampering with the jury. Tampering can only take place from the outside of the jury room. So when there's an infestation in the middle, inside the jury, and you are aware of it, you are to cut that infestation. Failure to do so, you have ratified, you have become an accessory, And you and it is a most unfortunate act, and it's not something that we must pretend like it never happened. Those are the facts.